Hello, everyone. My name is Jashinjit, and I'll be your host for today. As your host, it is my pleasure and privilege to welcome you to the webinar on Alternative Dispute Practitioner's Guide, How to Get Involved as a Young Practitioner. Now, before we begin, just a friendly reminder to all our participants, please ensure that your mic is muted at all times. If you have any questions, please type it down in the Q&A section or the chat section, and the moderator will address your question at the appropriate time. Now, we will now have a short ice-breaking session where there will be a short poll on the screen. So we encourage the participants to answer the poll as it will help guide the discussion later on. So I'm hoping that the participants are able to see the poll on the screen right now. All right, for my screen, it looks like 100% of you all have actually answered the poll. So let me just read out some of the answers. So the first question we asked is, did or do you find the ADR field too exclusive? A whopping 64% of you all said yes. Now, the second question we ask is, did or does your pupil, master, employer provide adequate exposure to get you involved? Now, 64% of you all said no. And finally, the third question we ask is, do you regularly attend social gatherings by legal bodies or organizations? Now, a whopping 75% of you all actually said no. So now that we know where everybody stands, let us move on to the next session of our webinar today. I would like to introduce our moderator today, Miss Louise Azmi. Now, Miss Louise Azmi was a barrister in UK from 2004 to 2015 until she relocated to Malaysia, where she was now admitted to the Malaysian bar and has her own practice in Mount Kiara. Miss Louise is also a door tenant at King's Bench Walk, London. Ms. Louise is a fellow of the Chartered Institute of Arbitrators and the Malaysian Institute of Arbitrators. She is also a qualified adjudicator and mediator. Ms. Louise has extensive experience as trial and appellate lawyer in both Malaysia and the UK. She's involved in cases from various fields such as constitutional law, administrative law, environmental law, construction, including oil and gas, and general civil litigation. Now, Ms. Louise is also the co-author of Practice and Procedure of Mediation, Thomson Reuters 2020, and a contributor to Practice and Law of Construction Law Malaysia by Sweet and Maxwell 2021. With that, Ms. Louise, the floor is yours.
Thank you very much, Jasminjit. Good afternoon and welcome to this afternoon's webinar on the topic of alternative dispute resolution, how to get involved as a young practitioner. We have three panelists with us this afternoon, each one of whom is very highly regarded in the field of ADR and ready to share their insights as to how you can get involved. Mr. Adrian C. is a partner at Belden. His area of practice is primarily construction and engineering disputes. As well as being a very experienced litigator, he routinely handles all forms of dispute resolution, including arbitration, adjudication, mediation, expert determination, and early neutral valuation. Ms. Delvine Dawson is the managing partner at George Rogesi. Her career illustrates her capabilities in corporate work, as well as land, construction, and insurance disputes. She has a wealth of experience advising and representing clients in alternative dispute resolution. She also has a diploma in international arbitration and is a fully qualified mediator and adjudicator. Last but by no means least, Mr. Darshan Dev Singh is a partner at Lee Hishamuddin. His primary area of practice is commercial dispute resolution, with a focus on complex disputes relating to construction, engineering, oil and gas and infrastructure projects. Dave sits as an arbitrator and adjudicator, and he also represents clients in litigation, arbitration, adjudication, and mediation. So this afternoon, our panelists will be sharing a little bit about how they managed to get into the field of ADR and what the participants in the webinar might also do in order to get involved in that field. But before we get into the meat of the topic, there may be some people who are a little bit unfamiliar with precisely what we mean when we talk about alternative dispute resolution. So can I therefore just start by perhaps we could cover the three main methods of dispute resolution in Malaysia. So those are adjudication, mediation, and arbitration. Adrian, can I start with you? Can you give us a little bit of insight into what we mean when we talk about adjudication?
Yes, thank you, Louise, for the introduction. And just to give all the attendees a brief overview on adjudication in Malaysia, we have both contractual adjudication and the more prevalent mode of adjudication, which is statutory adjudication. In terms of statutory adjudication in Malaysia, it is regimented under the Construction Industry Payment and Adjudication Act 2012, more commonly known as SIPA. It is administered by the Asian International Arbitration Center, AIAC. We are one of the few jurisdictions, along with the UK, Australia, New Zealand, Singapore, and Ireland, who has a statutory adjudication framework. Now, the Act, or SIPA, provides the framework for adjudication on all applicable construction contracts as defined by the Act. One of the key characteristics of adjudication under the Malaysian regime would be as follows. It is predominantly a documentary-based process, although sometimes hearings and clarification process will take place between the adjudicator and the parties if it's deemed suitable or needed. The start to end of the adjudication process is relatively quick. From the issuance of payment claim, it will take approximately about 5 months, give or take, for the adjudication decision to be rendered. An adjudicator's decision is binding until and unless it is set aside by court, or if there is a settlement reached between parties, or that the subject matter is finally determined in arbitration. Now, under the Malaysian regime, there are very limited grounds to set aside or to stay the adjudication decision. And I think there are ample case laws on this. So as a brief overview, since the introduction of SIPA in 2014, it has become a major form of ADR, the go-to ADR by parties in the construction regime, and that has obviously created a big space in terms of workload for the ADR community. Now, with that, I think I'll hand it back to you, Louise, for the other modes of ADR.
Yeah. Thanks very much for that, Adrian. So that covers adjudication. Ms. Delphine, perhaps you might like to explain a bit about mediation.
Okay. Well, long before I got involved in the legal mediation, I was already mediating all the fights between my children. So that makes me quite an expert. But seriously, with mediation, I think it's one of the most peaceful ways of settlement. It's natural, it's a normal process, it can be done successfully. All you need is a little bit of training and good communication skills, good relationship skills, and of course, emotional intelligence. If you can have all this, then you can go for a little bit of training, that's all you need. In mediation, the mediator has to be impartial, he's a neutral party, and his or her primary duty is to assist the opposing sides in a dispute to achieve an agreement. Mostly it's party-centered, what the parties want, their rights, their needs, their interests, and the mediator's duty is mostly to improve the dialogue and empathy between the parties. So the skilled mediator, usually after this training, you will use a wide variety of techniques to guide the process in a constructive direction, and you find an optimal solution, and the mediator will refrain from giving prescriptive advice like you should do this or you should do that. They refrain from that. The skills of the mediator is actually bound to assist parties to improve dialogue between them, and then they can achieve a mutually agreeable outcome. Once reached, parties can have a written agreement that is signed by both parties, and this can be binding on everyone. That's it.
Thanks very much for that. Then Mr. Darshan Dev, I know you sit as arbitrator as well as representing people in arbitration. Can you just tell us a bit about what that's about?
Thank you, Louise. Thank you for the introduction. I'm trying to keep it as simple as possible. Arbitration simply is a process where you can basically appoint an individual or a group of individuals to basically hear your dispute, determine the dispute, and the decision is then enforceable in over 170 countries. The key features that needs to be looked at when you talk about arbitration is, first of all, it is contractual in nature. What I mean by contractual in nature is that unlike adjudication, where it is governed by a statute and one party can initiate adjudication and the other party can't say, I'm sorry, I'm not going to participate in the adjudication. It doesn't work as such in arbitration. In arbitration, you need to have an agreement. You need to have a contractual agreement between the parties, and usually it's in the form of an arbitration clause in a contract for you to be brought to arbitration. So let me give you a simple example. If one party wishes to commence arbitration and there is no arbitration agreement between the parties, the other parties can refuse to participate in the arbitration. So it's very contractual in nature. The second key takeaway on arbitration is in terms of its enforceability. Unlike courts, litigation, or even adjudication where you get a decision and it's enforceable in Malaysia, and if you wish to execute it against the assets of a particular losing party, which say it's in the UK or in China or even in India, you may have to recommence the entire process of litigation in that jurisdiction in order for you to then get a judgment in that jurisdiction and then carry on your execution process. So if a company has got assets, say in 10 countries, typically you would have to commence 10 different litigation, incur costs, time, and then basically you'll be able to execute the assets. Whereas in arbitration, the unique thing about arbitration, so long as you're part of the New York Convention, which I think at the moment there's about 170 states, if I get a decision of an arbitral award in Malaysia, and the company has got assets all around the world, I just need to take the award and enforce it in all these countries where they are part of the New York Convention without having the need to go through the entire re-hearing of the dispute on its merits. And I think one of the famous or more talked about incident recently is the case involving the Sulu Sultanate Air, who seems to have gotten an arbitral award, whether rightly or wrongly, and are going around the world to try to enforce and execute it against the assets of the government of Malaysia. But that's a discussion for another day, or for another topic. Why would parties go for arbitration? Why should I go for arbitration as opposed to court litigation? Primarily, there are various reasons, but some of the primary reasons are: number one, confidentiality. You don't want trade secrets or certain informations of how you run businesses or the fact that you're having a dispute to be out to the public. Number two would be expertise. You perhaps want an arbitrator who has a particular technical knowledge. Say if you're dealing with an issue involving a plant, an energy plant or a power plant, it's not necessarily that if you file a case in court, you might get a judge who has got necessary experience in dealing with such technical matters. So the beauty of arbitration is you can pick the right man for the job. The other thing also, I would think, is if there's a contract involving two foreign parties, they may have this lack of trust in the local national courts of that particular party. So they would then agree to an arbitration to be held elsewhere, which is foreign, to both the parties. Essentially, that's what our arbitration is. And to round up on arbitration before I pass the floor back to Louis, I would say that typically there are two types of arbitration. One is ad hoc arbitration and the other one is institutional arbitration. What we commonly would know is that there are various arbitral institutions who promotes arbitration and there are sets of arbitration rules, but not to forget, you can also have arbitrations without any arbitral institution's rule or involvement of any arbitral institution. And that's what you call an ad hoc arbitration, where the parties autonomously agree on the rules and the procedures that is applicable to that arbitration. Back to you, Louise.
Thank you very much for that. So that gives a really good overview of the three main types of alternative dispute resolution in Malaysia. But what people might be thinking is, how do I actually go about getting into that? How do I get involved? So Adrian, can you share some of your thoughts on how people can get involved, perhaps first of all from the perspective of legal practice? So say you're just beginning in legal practice, what can you do to get into this area?
Yes, thank you, Louis. I think what is interesting to note is that I think the very fact that the attendees that we have today, obviously there's a keen interest to get involved in ADR practice. But what is interesting is, I think my fellow panelists and you yourself would note from the poll would be the perceived challenges in terms of breaking into ADR, because I think majority of the attendees felt that ADR field is too exclusive and they're not getting adequate exposure to get involved in ADR. Now, of course, without the background of knowing what led to these choices, I think one of the key aspects for a young practitioner to look out for will be the ADR practice that they want to specialize or be in. Because in this day and age, in terms of a legal practice, there are many boutique firms and also departments within the bigger firms that offers or specializes in ADR disputes, be it arbitration, adjudication, so on and so forth. There are also within the ADR practice or the ADR community, there are also different areas of service or industry, such as construction, maritime, or corporate commercial disputes, to name a few. So I think first and foremost for a young practitioner, what they could look at is perhaps the area of interest in terms of the service that they would want to specialize in, and to pick the right firm to try out. And as a young practitioner, involvement through legal practice will likely come in the form of being a junior counsel acting for a party in the appropriate ADR forum. So if you're talking about adjudication, if you're talking about arbitration, as Dave has aptly pointed out in terms of the roles of parties counsel, a young practitioner will learn the ropes by assisting the senior counsels in terms of the case preparation from the early stage of the case when the client comes to you, interviewing the clients, getting the facts right, putting up the documents, and even attending hearings. The target for a young practitioner should be to absorb as much as you can during your early years, and to learn the ropes of what it takes to get the job done. What a young practitioner ought to take note is to bide their time, not to rush things too soon or too fast. Because if you're talking about the end game of being a mediator, an adjudicator, or even an arbitrator, the various qualifications that are required will certainly require a number of years in practice before you can even enable yourself to qualify to become one. So what one should focus on, I feel, is to take the early years, perhaps the first 5 to 7 years of your practice, to build your knowledge, maintain that knowledge, and to equip yourself with the right tools so that when you eventually qualified to become an adjudicator, arbitrator, or mediator yourself, you're in that position or state of readiness to join in the industry, so to speak.
Thanks very much, Adrian. Darshandev, I just wonder whether there's anything you want to add to that from the perspective of a big firm. I know Lee Hishamuddin, if I'm right, it's the biggest, I think, in Malaysia at the moment.
I don't think we are the biggest, but we are one of the largest law firms.
Yeah. So is there anything you want to add from the perspective of, is there any particular advantage, particular disadvantage to being in a big firm? Is it a better platform or an easier place from which to start to get involved in ADR?
Thank you, Louise, for the question. Focusing on your question, which is whether is there any advantage in joining a big firm or a large firm in enhancing your career in ADR? Personally, for me, I would think the answer is yes. And the reason for that is because one is about picking the right firm which specializes in the particular ADR practice that you're interested in. For example, let's take arbitration, for instance. And as we know, arbitration by its very nature is international, it's borderless. And many of the cases that come to large firms are usually complex cases and involve cross-border works. And that requires you to basically have arbitration held not only in Malaysia, but also outside of Malaysia. So if you're a young lawyer who is eager to learn and who has very high ambition, wants to grow out there and wants to become an international practitioner someday in terms of arbitration, I think a big firm would be a good platform, because taking into account the complexity of the cases that is involved, the volume of cases that come in, and the international exposure that you get from it. And the other thing about a large firm is that there is a structure in place, and there is a group of lawyers or partners who works in a particular department, say, for example, arbitration. So as a young lawyer, you'll get an opportunity to learn and gain experience from lawyers of different seniority and different level, depending on the case that you are involved in. That's my take on that.
Thanks very much for that. Ms. Delphine, anything that you want to add from the perspective of what can people do when they're starting out in legal practice in order to get involved in ADR?
Well, nowadays everyone comes out even with an LLM by the time they get their degree, and you would have specialized in some area there. So if there is any of those subjects that you had studied, it's not necessarily just the LLM, but even if you don't have that subject, you can go into firms where they want this kind of criteria, you see. I find that I come from a small firm, and it was a struggle. Even now, it's a struggle with breaking into ADR practice, you see. Although we have practiced for 10 years, we need to, I'm sorry to say this, Dave, but we need to mute the dominance of all these big firms, you see. And I'm happy to see there are many boutique firms now that have cropped up, you see, practicing ADR. And I echo your sentiments that the young practitioners should join those firms, even if it's a small firm without a ADR department. You can join those firms and get some knowledge and experience before moving on. And because your first years of practice are your formative years, and I think you can switch firms, depending on what they're offering and what exactly you are looking for. Get out of your comfort zone. No matter how happy you are in a firm, you're young, you move on, just move on to firms that are offering and you believe can offer you something that you are happy with. That's my take.
Thank you. So I think one thing that for certain that everybody's clear on is just get as much exposure and as much experience as you can early on in practice. The other aspect of that, I mean, clearly that relates to practical experience, but what about academic qualifications? Any thoughts about what young practitioners might do in terms of getting qualified in ADR? Adrian, maybe you want to talk us through a little bit about maybe start with adjudication, what people can do to get qualified.
Sure, Louise. Well, I think in terms of ADR practice, like I said, and I think all panelists agree, your first few years, your first few formative years is important to absorb as much as you can. But in terms of, because nothing beats practical on-the-job training, I think we all agree on that. No one case is similar, and hence you've got to learn your ropes and really bide your time. But in terms of adjudication, a prerequisite in becoming an adjudicator under AIAC's banner for SIPA-related adjudication will be to sit for the adjudication course conducted by SIPA. And I think there is a prerequisite. One has to be involved in the industry one way or another for a period of 7 years before you can sit for that. So if at all our fellow young practitioners are interested or keen to take that route or pursue that route, you still have got to wait that time. Because put it this way, at the end of the day, the legal industry is an industry. It's a service-based industry. And nobody will go to a young adjudicator, young arbitrator, or even young mediator with no experience behind them. So experience is really key to everything. But in terms of adjudication, yes, the adjudication course conducted by AIAC is the prerequisite. And then once you pass the exam, or once you pass the course, you've then got to empanel yourself with AIAC, and that's about it. But once you get empaneled, then you've got to wait for your appointments, and from there you work your way up. I believe that's how it is for all of us here.
Thanks very much. Darshandev, how about arbitration? I know the big one is, you can take qualifications through CIR, for instance. How fundamental is that? Would you advise people to start looking into that?
If you were to ask me this question about 15, 20 years ago, my answer would have been slightly different. I think about 15 to 20 years ago, many arbitrators worked their way up through experience and exposure in that industry and doing arbitration work. And then eventually you get an invitation from the arbitral institution who recognizes your experience and your capability and empanel you as the arbitrator. Fast forward to where we are today, there are many organizations who conduct courses, and there are many arbitral institutions who makes it a prerequisite for you to have certain qualifications in a particular ADR field in order to be considered to be empaneled as an arbitrator. And one of the common courses that one takes in order to move up as an arbitrator is the fellowship course under the CIR that is provided by CIR, where you work your way up. And that, just to remind the participants, is just a minimum requirement for you to be empaneled. At the end of the day, you would still go through the processes of the respective arbitral institutions in order to be empaneled. And as a young practitioner, what you also need to show, and this is where I echo what Adrian said, I'm a strong believer that in order for you to move up the ranks, you need to get your hands dirty, and which means you got to do practical work. You got to get on the job and you got to do it. And I realized quite a number of arbitral institutions over and above your qualifications or your certification in any arbitration module, they also would like to see your experience in having been involved in arbitration related matters. Because like it or not, being an arbitrator, and I say this very firmly, it's not a fancy job. It's not a money-making job. is a job where you have to take on, in Arabic, the words used is amana, or responsibility, because you're making a decision at the end of the day for either one party is going to be unhappy with the decision and the other party is going to be happy with it. And one party is going to be deprived of certain things coming out of your decision. So it's very important that when you make a decision as an arbitrator, you take your responsibility very carefully and you make a right decision for or against the correct party. So personally, I would feel that you should get yourself exposed to the arbitration scenes, get enough experience. And if you tell yourself personally that I am now capable enough to make decisions that will be just and fair to the parties, only then take on the role. But do not ever take on the role just because it's a fancy title or for the fees. That's a very wrong reason to be an arbitrator. Thank you.
Thank you. Ms. Delphine, perhaps you might like to tell us a little bit about what you need to do to be qualified as a mediator, whether there's any qualifications or courses that people could get involved with.
Okay, Louise, as for me, I'm speaking personally, my journey started with doing the mediation course, which is offered by the Malaysian Bar. I did that, but now currently I know that AIAC offers it, and there might be other training bodies that offer mediation training courses. But like I said from the start about mediation, if you're keen to be a mediator, you have to love people. You have to be a people person, your skills with people, because they will be arguing, you must know how to handle, so these trainings are always vital in that sense, because they will teach you what to do when people start fighting and things like that, you see. My advice to the young practitioners is you go for those trainings, and once you've finished and you've passed that qualified, they will empanel you under the Malaysian Bar or the AIAC, and then you're not going to get your mediation work, definitely. What I suggest is make friends, and co-mediate. Sit as a co-mediator. That's how you're going to get your experience, because with mediation, I think you will only get the skill and the experience after co-mediating. You cannot sit as a mediator immediately after the training. It calls for a lot of, then you might make matters worse in that sense, because with mediation, people can get quite aggressive when you're mediating, you see. That's my advice.
So the qualifications, good idea, but not in isolation. Obviously, that needs to be hand in hand with getting practical experience. Something I know a route that some people take is to be employed by one of the ADR institutions and get some exposure that way. Now, I know that all of us on the panel are lawyers. None of us have approached it that way, but I just wonder whether maybe we can share some thoughts on whether that's an avenue that people could go down. Adrian, I'll come to you first, just to ask if you got any thoughts on that.
Yes, I think certainly I have encountered my fair share of institutional case counsels, I think whether in AIAC or abroad, who have opted to gain exposure being case counsels, because as case counsels, they get to familiarize themselves with the rules of the institution. They get to administer the arbitration, both domestic and also international, or even depending on the institution they are in. And most importantly, they get to expand their network, because in the course of their work as case counsels, in terms of the conferences held by the respective institutions, they get to build their network over time with parties representatives, parties counsel, or even the arbitrators themselves. Eventually, when the time is right, they either move on to a different institution, or they join an international setup, international arbitration setup, or they go back to their home countries to practice. And I find that they are all quite successful now in terms of where they are. because having that exposure with the institutions does play a part in the minds of the prospective employers, or even when they want to set up on their own, for example. So that's based on my observation. I'm sure other panelists may have their own observation as well.
Yeah, Dashandev, anything you can share about whether you think it's a good way into things to go through one of the ADR institutions?
Well, certainly there are benefits in going and being attached to an ADR institution. And some of the immediate benefits that I can think of is, number one, you will be exposed to how to manage an arbitration from the outset, from the registration of the case, right up till the end, which is the issuance of the award. Although you may not get the experience that you get in a law firm, which is drafting and dealing with the case substantively on its merits and gathering documents, but certainly from the procedural aspect, you'll be able to see the case through from the beginning till the end. And that gives you a bit of a exposure in terms of the administrative aspects of the arbitration process. The other benefit that comes to my mind is also reviewing awards. Many arbitral institutions has got a provision in their rules that the arbitral tribunal would have to submit the awards to be reviewed by the institution. And that's another whole process itself, where you review how an award is drafted. And because they have the benefit of seeing multiple awards from different arbitrators, they would be able to gain insights as to what is a good award and what is not so good award, and what you should do when drafting an award and what you shouldn't do when drafting an award. So they get more exposure in terms of seeing much more awards being drafted than you see in practice. The other aspect of being attached to an institution is also many a times when a government or the institution wishes to make any amendments to the rules or legislation, one of the stakeholders that will be called out for are the institution. So the young practitioners who are attached to them would get an opportunity to be involved in the rules committee, to assist in amending the rules, to assist in proposing amendments to rules, and also to be on the lookout at what's happening in the other jurisdictions, including other arbitral institutions. Whether are they coming up with a new rule? Should we introduce it, say, in Malaysia? Why and what are the amendments? And not to forget, and the last but not least, which is the much more on lighter tone, many of the arbitral institutions have a lot of events. So you get to network and you get free booze. So that's a good thing.
There you go. What more could you want? So since we've touched on networking, Ms. Delphine, perhaps we can just have a think about that. I mean, speaking as someone who came from another jurisdiction, one thing I found really useful when I first came to Malaysia was just attending lots of networking events, speaking to people, asking questions, finding out what's out there. What can young practitioners do to get involved in those kinds of circles?
Well, nowadays there's so many seminars, conferences, and things like that being organized by different bodies, the Malaysian Bar, AIAC, ADR, So you definitely have to attend this. I found at the last international conference, ADR conference that was held, that there were many youngsters there, and they were being sponsored by certain bodies. So it's a very good platform to meet, and it was very nice talking to all of them to see their interest and all. And they said that by joining, who sponsored them, they do some of them are embarking on their PhDs. So they come to AIAC and sit there to do some research and things like that. Definitely, and this will help them in their networking stage. For mediation, like Adrian and Dave talked about adjudication and arbitration, and I agree that if you join those institutions, you will be exposed. But for mediation, it's slightly different. It's not like that at all. So I think with mediation, I'm just speaking for mediation a little bit. This networking sessions, you will meet other mediators and you can give them your card, get to know them, keep that friendship, and you can co-mediate. Like I said, if they are invited to co-mediate with them. And definitely like the sports arbitration, that's a new one, sports arbitration, which was, I think the AISE, I joined the inaugural batch on, and they have a new section. So you see, if you're interested, keen in sports and all that for the youngsters, this is a new practice area. Get yourself involved, network with the people, with SLAM. I think it's called SLAM in AIAC, and get to know them. Definitely you will benefit from all this.
Thank you. Adrian, any thoughts on that? Where can people, what sort of groups can people join that are useful for networking and getting to know other people in the ADR industry?
Well, thank you, Luis. I think first thing that came to my mind is for young practitioners, even within in the Malaysian context, if you talk about CIR, if you talk about MIR, if you talk about the AIAC practitioners group, all of them have a young practitioners group which is catered for young practitioners. So as starters, I think for young practitioners who are keen to develop or to further extend themselves in ADR practice, to join these groups, to build your network from there, from your fellow peers, to share your experience. It allows you to share your experiences, whether you're in a big firm or a small firm, to also find your own footing, because sometimes as young practitioners, and if you are in a smaller setup, for example, and if you're the sole young practitioner there, you may not know whether what you're doing or whether the path you're on is the right path and all that. So having peers or having colleagues in the same industry who can share their respective views will be reassuring to a certain degree. And from there, you should get yourself involved in the events that are being organized. That should also help build your knowledge, along the way, and maintain this network. Because over the years, as you grow more senior in practice, these are your peers who will grow along with you, and soon enough, you will rely on one another in this industry, like it or not, because it's a small industry, whichever area of practice that you are in. So I think in terms of for a young practitioner to look into the various organizations, young practitioners group, to start from there. And of course, like what Delphine and Dave has mentioned, conferences, events are something that helps you to relax, but as well as to build your network. So expand your horizons as much as you can.
Thank you, Adrian. Darshan, Dev, any thoughts on that?
Thanks, Luis. Networking for me is key. You cannot, in this time and age, run a practice or run a successful practice without networking. A simple analogy I will give is you may be a good lawyer based in Wakanda for all that it matters. But if no one knows who you are not going to get the amount of work that you can get. Simply put, you may be as good as you are, but if no one knows about you, no one's going to come to you and give you the work. And today, networking is very, very, very important. And things have changed compared to where we were many years ago. Compared to where we were many years ago. Today, networking has been so much more easier. The outreach is far more. Let's take LinkedIn, for example. One post and you get thousands of likes, thousands of views, and it gets, the outreach is quite far. The other thing would be in terms of networking, I do agree with what Adrian has said, seminars, conferences, webinars, lectures, these are important avenues where you get to meet people, you get to talk to people, and you get to know your peers in the industries. So yes, my view is networking is key.
Yeah, I mean, I can echo that because I remember starting in practice and my attitude was, well, if I do the job well, the work will come. And it took me a while to realize the work will only come if people actually can see you and get to know who you are and have some confidence in you.
But Louis, if I could just add to that, sorry, and I think it's important to tell to young practitioners, whilst networking on, say, social media and promoting yourself to the world at large, you need to walk the talk. What I mean by walk the talk is when the work eventually comes to you, you need to deliver and you need to give high quality work, because no point going on and just marketing yourself, and when the work comes to you, you don't perform, the words will still pass that you are still not a good lawyer. So it's a double-edged sword.
Yeah.
You got to make sure that you're good and you do a good job and you market well as well. Because if you don't do a good job by you marketing to the world at large, when a bad word comes out, when a bad remarks comes out, it will go to the world at large as well.
Yeah, we were always told you're only as good as your last case. So it doesn't matter what you put there on LinkedIn, people will know whether you've done a good job or not. But I mean, when you talk about LinkedIn, I suppose networking these days, we're doing it physically. But what about marketing and social media? What do you think about that? How much is too much, for instance? Adrian, any thoughts on what you'd say to people about putting things up there on social media, Instagram, LinkedIn?
Well, I think I echo the sentiments that Dave and you have mentioned, Louis, and even Delphine. If you go back 10, 15 years ago, do your job right and the work will come. But in today's world, in today's age, social media is a huge presence. LinkedIn is a huge presence. I think the key for me is you don't want to lose out, meaning to say if you're good at your work, you must be seen to be good at your work as well. And you must, there's nothing wrong in sharing it on social media. But bearing in mind, as lawyers, first and foremost, you have the rules against publicity and also to maintain the integrity of the profession. It is important not to go overboard. So I think in terms of LinkedIn postings that you see nowadays, a majority of the firms employ, I would say, similar techniques in terms of, firstly, it's based on knowledge sharing. So if you are informing the world about the latest developments in the law relating to your industry, the latest developments, the latest case law, all of these are within the confines of what is permissible, I believe, and even in terms of getting recognition from the various bodies who evaluate and assess lawyers in terms of worldwide. So as long as it's done within the confines of what is permissible within the industry, I don't see there being anything wrong with it. So long as you don't go overboard in championing yourself and all that. And I think none of us do here. So the key to me is really ensuring that you don't want to lose out in this day of social media and social media age. Just do enough. Keep your presence, keep abreast with what is happening around the industry, and ensure that you live up to your end of the bargain at the end of the day.
Thanks very much. Delphine, any thoughts on that?
I think the young practitioners have one up against people like me when it comes to social media and things like that. So I think you should make use of that, within the boundaries that the Malaysian bar allows you, or you can. I think it's a very good idea to post your. You can analyze cases. You can do all that. You don't have to be in a big firm to do that. You can post it on LinkedIn, which everybody is doing these days. And like as Adrian says, if you're not in it, you're going to lose out. So go, use it. Social media is good.
Yeah. And Dash and Deb, for you in big firms then, is this a lot of what you're doing these days with marketing? Is it a lot around social media?
It depends as a firm or individually. As a firm, I think Leisure, Muden, Ellen and Gladale is one of the few firms, I'm not sure if it's the only firm, who has got posting almost daily on its LinkedIn. And sometimes, and why I say this is because I'm in charge of the LinkedIn for Leisure, Muden and Gladale. And there are times when there are two different partners who say, look, I've got my post, and the other person says, I need to go first, and the other said, and then I need to make a decision. Okay, hold on. Is this urgent? Why should yours go first, and why should the other person be pushed back? So, from my experience, almost daily, we have got one post at the very least. Sometimes we've got even two posts in a day. So, as a firm, yes, we have been quite aggressive, I would say, in terms of knowledge sharing. For the benefit of the public at large. So that's as a firm. Individually, I'm not sure. What do you guys think? Am I active on LinkedIn? I don't know, but I do make an effort to post on LinkedIn as and when I can. Yeah. But I do totally echo what Adrian and Delphine have said. Digital marketing in this time and age it's very important, and unless you get into it, you will lose out.
Yes, can I just add something to that? Because more importantly, I believe by posting these things, even individually, it will increase your confidence, especially when you see people's comments, their positive comments and things like that. It'll inspire you to continue doing this, you see. So it's a good platform.
And taking on from what Delphine has said, it's good that LinkedIn, I think, is still a little bit more civil when it comes to comments. There are other social media platforms where you get adverse comments. I mean, I've not seen it when it comes to a legal profession kind of situation, but even looking at how the social influencers are, even on other social media, whatever post it is, you'll get a fair share of positive comments. You'll also get a fair share of negative comments as well. But the good thing is, I don't think LinkedIn has embarked into that sort of arena as yet, hopefully.
Yeah, it's much more professional than lots of other platforms, I think, isn't it?
Yeah. So
we're fast approaching 4 o'clock. So I just want to give you all an opportunity, maybe just for a couple of closing remarks. What, if you could encapsulate it, Adrian, into a short couple of sentences, what would your key points of advice be for young people starting out?
Well, if I'm to concise it to one word, it will be to first add value to yourself before you think about promoting yourself to the world. So I think it's good to have a good base to expand your career. And that would be it.
Thanks very much for that. Delphine, in terms of final words of wisdom?
I really think you must tailor-make it to be unique to what suits you as a professional, and you follow the best part that suits you according to your beliefs. You see, that's what you should do to progress. And this must be a concerted effort as well between, once again, I say, between law firms, mediators, arbitrators. If only inclusion is pursued, and then I believe the profession can grow and benefit the next generation of ADR practitioners, you see.
Thank you. Dash and Deb?
I'll try to keep it short. What I would advise the young practitioner is, number one, know what you want. It's very important that you know what you want at this stage itself. Don't tell yourself, it's okay, I'll work for another 2-3 years and then I'll decide what is it that I want. A lot of candidates that come in, even at a pupillage stage, have already done their thorough research and know exactly which area of the law that they want to practice in and which area of the ADR process or dispute resolution process they want to focus on. And there is no excuse for you to say, no, we can't know that, because today, every information that you need is just at your fingertip. And having known what you want, you should know how to get there. And I think there's a lot of resources out there in terms of knowing how to get there. And one of it is attending the webinar today, where we have actually shared with you from our personal experiences on how to get there. So that will be my 2 takeaways to the young practitioners who are watching us today. Thank you.
Thank you very much for that. So thanks everybody for joining the webinar today. It's been a really lively discussion, and I'm sure that everybody who participated got something from that. So thank you very much. And with that, I think we're just approaching 4 o'clock, so it's probably time to leave the webinar.
All right. Thank you so much, Ms. Lewis. First and foremost, I would like to thank all the panelists for being here today and sharing their experience. I am confident that all the attendees have definitely gained a lot of knowledge, especially for someone like me. I'm a young practitioner myself, just getting into the ADR field. So I definitely learned a lot. Secondly, I would also like to thank our dear moderator, Ms. Louise Azmi, for doing a great job. Thank you so much. And before we end the session, I would just like to make 2 announcements for our participants. First and foremost is that we have an upcoming workshop on how to draft a construction claim. So if any of the young practitioners are interested in finding out more about how to draft a construction claim, it will be taking place this 16th of December on Friday. You may register by scanning the QR code. And if I'm not mistaken, the poster should be on your screen right now. However, if you're unable to scan, please go ahead to our LinkedIn, our Instagram. The poster should be there and you should be able to sign up from there.